Okay. Welcome, everyone. Welcome. Today is Thursday, April 17th. It's a Rec Lab mentor and a workshop day. We have our amazing guest speaker with us today, Anusha Kakani. Many of you have met her at the beginning of this semester. Oh, hold on just one second. Excuse me, what? Okay, I'll do that. I'm going to make Anusha co-host really quickly. Many of you met her at the beginning of the semester, and she's going to be there. We go, and or in previous semesters, she's an amazing mentor. She's an attorney. She's well known, well versed in the startup world. She can help with a lot of different issues, but particularly issues when it comes to fundraising, like early stage fundraising. And I know some of you are working on that right now. And so this is perfect timing for this. Just to let everybody know, the meeting is being recorded. We do put videos of all of our recorded workshops up on our YouTube channel, and Ash will share the link with you in the chat for the YouTube channel in just a bit. But I'm done talking about enough. I'm going to just ask Anusha to talk. Anusha, are you here? Can you hear me?
I'm here. Hi. Can
Hi,
everybody
good
hear
to see
me?
you. Oh, thank you so much for being here, especially when you were feeling unwell. I mean, I really, really, really appreciate this. So, and I know everybody else does as well. Opla. Oh, that's okay. It's okay. Let me just make it so that they can see you and not me, and make sure that you can share your slides. So, if you want to pull up the slides for just a moment, and then I'll make sure. And then I'll make sure that we can all see you. There we go. All of us should be able to see Anusha there. And then
make sure.
And so you should be able to share from the bottom of the screen. You might be able to share them there. Or...
Yeah.
Okay, great. Awesome.
All right.
All right, we can see this. Yes, we can see this now. Good.
Okay.
And
Is this full screen now?
It's full screen now. Yep,
okay,
it's perfect.
Great. Fantastic.
Good. So would you like to go ahead and introduce yourself and tell everybody a little bit about who you are and what you do? And yeah, I'll let you take it from here.
Sure. Thank you. First of all, thank you so much to the rec team and to Tanya for letting me do this virtually. I haven't been feeling well, so if you see me go off video or needing to take a break, just please bear with me. So as Tanya said, we're really going to talk about early stage funding today. And before we dive in, a little bit about me. I'm a corporate and social impact attorney. What that really means is that I have a real passion for working with early stage founders from diverse backgrounds. When I say an impact attorney, I mean that I also work really closely with nonprofits. So I have a lot of mission-driven startups that I work with. I have nonprofits that I work with. And my practice really integrates a lot of emerging sustainability, social equity frameworks with really high caliber corporate expertise. Before I started my practice, I was at Big Law. I come from Harvard Law School, and then I went to Sherman Sterling, now known as A&O Sherman. Then I worked at Cooley for a few years, and then I started my own practice so that I could really focus on this kind of work, which is what I wanted to do. So I work with companies, investors, nonprofits, and my practice is generally corporate, and it covers a broad range of industries like tech, including biotech, deep tech, AI, which we're going to really talk about today, as well as consumer goods, sustainable agriculture, health and wellness. So really across a broad array of industries. And I really want this to be, as interactive as possible. I know it's a little bit difficult when we have an online format, but to the extent that anybody has questions, please put them in the chat or feel free to chime in if we're able to. If not, at the end, we'll definitely have time for a lot of questions. So we'll just kick it right off. So today what we're going to cover is we're going to talk about fundraising, setting a fundraising strategy for your company. And what that encompasses is really getting a good understanding of some concepts, including equity, governance, cap table management. We're then going to talk about what the typical company life cycle looks like, particularly focusing on the early stage and what that funding looks like, including talking about pre-seed, seed, Series A, and beyond. For that portion, we're really going to be focusing on more of a venture capital growth strategy. That's really what we're talking about when we talk about, like, if you guys have heard of the terms pre-seed or seed or Series A and beyond, those are because that's sort of like the typical lingo, and we'll talk about what that means. We also need to understand what preferred equity is. So a lot of people might be familiar with common stock, but there's also a class of stock called preferred stock. And when you get into these fundraising rounds, what you're doing is you're issuing preferred stock. So we need to understand what that really means. Then we're going to cover what are some common early stage funding issues that people run into, go over some key takeaways for founders. And then we're going to talk about current trends. Sorry, that says trends in fashion law. That's a typo, but we're just going to talk about current trends when it comes to fundraising. And what this graphic really represents is that if you're considering all of these various things, that's sort of how you can set yourself up for success in early stage funding. So, setting your fundraising strategy. First and foremost, we need to talk about various entity types, because let's say you have a corporation versus you have an LLC, your fundraising strategy might be different. And I think you guys already covered, the basic entity types, like corporation versus LLC. But one example is, we're going to talk about venture capital funding. A lot of VCs, or when I say VC, I mean like a venture capital fund, they won't even invest in an LLC. LLCs have certain restrictions on who the owners can be. For example, like if you want S Corp tax treatment, which is like pass-through entity tax treatment, that has restrictions on institutional holders being the owners of that entity. And so if you have VC money, they typically want to see that you're formed as a corporation. So a lot of today, what we're going to talk about is really referring to corporations. There's also other entity types. Tanya, sorry, I think you wanted to say
Oh, no,
something.
I was just going to ask, would you like to take the questions at the end? Would that be the best, since we have such a little
Yeah, let's just do that, I think.
Okay,
Yeah.
okay, we'll keep it to the end then, okay.
But if people want to put them in the chat as they're thinking about it, that's fine too, so they don't forget.
Perfect.
So, you've got the corporation. That's really what we're going to talk about today. You also can have partnerships. You also can have nonprofits, obviously. And so I know a number of you might be thinking about starting a nonprofit, or might be thinking about having an LLC. And so some of this might still be relevant, but when we really get into the early stage funding piece of it, it's really about corporations. I also wanted to mention public benefit corporations here, PBCs. I don't know if you guys saw the news, but OpenAI recently became a PBC. OpenAI is actually a really interesting structure. They have a nonprofit that has a for-profit arm, which they've now converted to a PBC, a public benefit corporation. That is like, PBCs are like my jam. So if anyone has questions about that, I'd love to talk about that. There's also something called a professional corporation, like as a law practice or a medical practice. If you have a professional license that's tied to your service, you may have to register as a professional corporation, and that would have sort of additional restrictions. So one example I'll give you is like a medical practice. Medical practices restrict who can actually own that entity. It's because they don't want non-doctors interfering and telling a doctor how to conduct a medical practice. So if it's a medical practice for a doctor, only doctors can typically own that practice. There's some rules in there where you might be able to have like a hybrid corporation where you have like some nurses, some doctors, that's like known as a medical corporation. Those rules also differ state to state. So understanding who can actually own your corporation is really important, because you don't want to start giving equity to people that can't actually own your corporation. So that's sort of the entity type discussion. There's lots more to dig in there, but we'll just sort of leave it as introductory for now. Then you have to consider, what are your goals for your business? So that's also your current ownership, your current goals, but also your future goals. How do you plan to fund the growth for your business? What do you want your business to look like in 5 or 10 years? Who are your investors? Are they going to be individuals, or are you going to approach like VCs or private equity firms? Or even what we're seeing increasingly is a lot of companies. For example, Qualcomm has an arm, Qualcomm Ventures. They go and they basically are like venture capital arms of these various companies that are looking for small startups or small companies, emerging companies that they can go and invest in. The other thing you need to be thinking about now is, what is your exit strategy? Even though it sounds crazy, like I just started my company, why would I be thinking about that? Because in this kind of environment, especially, we're seeing more and more like early stage M&A, for example. Like maybe the best thing for your company is actually to sell to a bigger company. A lot of times you'll see this in, for example, fashion, or you'll see this in drug development. This is because you might have a great idea, but to really scale your company, you might need like much larger resources than are available to you, or even any single institutional investor. You may need sort of the infrastructure of a larger company that is already established in that field. And if your exit strategy is an IPO, like you eventually want to go public, then you'll be following sort of that Series A, Series B, Series C route until you do your eventual IPO. So all of this to say, it's really important to think about, like, what is the business I'm starting? Is it going to be like a mom and pop shop where, for a lot of mom and pop shops, they can be an LLC the entire life of business. They're not really looking to give equity. Their fundraising is really, maybe it's like friends and family, or maybe they're really funding their operations using their revenue and they're not really looking for outside funding. That's going to have a totally different strategy versus a company that's like looking to do the typical, we need to have institutional investors, they join our board, they become our equity holders, and they help us grow our business. That's a totally different fundraising strategy. So these are all sort of like puzzle pieces that you need to be thinking about now so that you can fit everything together into your fundraising strategy. So understanding equity. Equity is ownership in your company. So if you're the sole owner of your company, you have 100% of the equity. It's really your ownership interest in the company, right? So in an LLC, you can talk about, it might be called membership interest, or sometimes they use the term units. In a corporation, when you're talking about equity, you're really talking about stock. So you can have common stock, you can have preferred stock, and then together, when you account for all of that together, each person's ownership percentage is their equity in that company. Really important things to remember about equity. Equity is a security, which means it's subject to federal and state securities laws and regulations. So what that means is every time you issue securities, including equity in a company, including LLC membership interests or corporate stock, that equity either has to be registered or it has to be sold pursuant to an exemption from registration. One thing that I notice is a lot of startup lawyers out there aren't necessarily securities lawyers, and so they're not advising on this particular piece, but it's extremely important because if you don't follow securities laws, the security itself can be invalidated, which means an investor can redeem that security or cancel that security, and it would be like a huge mess for the company. So common exemptions when you're early on, for example, for founder stock, there's a federal exemption. In California, you still actually have to provide a notice to the California Department of State when you do a founder stock issuance, to the Department of Finance, I believe it is. There's also other exemptions like Rule 482, which is for private placements. And then the other really common one that everyone relies on in the early stage is Reg D, which applies to accredited investors. So you'll probably hear the term accredited investors a lot. This is like particularly if you're going after angel investing or if you're sort of in the pre-seed phase. If you approach somebody who's an accredited investor, then they can invest in your company pursuant to Regulation D. That's an exemption from registration. And so, I think it's like $200,000 is their like average annual income. If they're an individual, if they're a married couple, it's like 300,000. If it's like a corporation, it's like 5 million. So there's different thresholds to prove that the investor is an accredited investor. So sorry, real quick, going back to equity, the one thing that I want to make it clear, it's like we have to think about equity almost like a pizza pie, a huge pie, and you got to think about what is my slice of the pie, right? And so each time you are issuing equity, let's say you start off as 100% owner, the full pie is yours. Each time you issue equity, like the pie becomes a little bigger, but your percentage is getting smaller, right? Because you're adding other people on. And so that's sort of the real thing to understand about equity is like you have to understand dilution, you have to understand what your ownership percentage is, and how each time you're issuing equity, how that's changing. So again, we can talk more about that throughout this, but if anyone has questions, please feel free to ask at the end. And there's also the way that corporations are structured also has a big impact on your fundraising strategy and your fundraising outcomes. In a corporation, there's separation of ownership and control. So we just talked about equity. Shareholders are the equity holders. They're the owners of the company. What they're doing is they're investing capital. They're giving you money in exchange for equity, right? So they're the owners. The shareholders, they elect the directors. The shareholders also have to approve certain measures by law. So the typical Delaware corporation, for example, they have to have annual meetings. They have to have special meetings for certain things. So for example, establishing an equity plan, you need shareholder approval for that. So shareholders do their main job as an owner of the company is to elect the directors and also approve certain important measures. Now jumping to what the directors do. So the directors are elected by the shareholders, and the directors are who's responsible for the strategic vision and the oversight. So they are responsible more for achieving the objectives of the company. They also have fiduciary duties, such as duty of loyalty, duty of good faith, duty of care, duty of competence. So fiduciary duties means that, let's say I'm a shareholder, I can sue somebody on the board because I can say, hey, that board member didn't follow their duty, like they did something that's harming the corporation. They also face liability for the company at federal, state, and local levels. So the directors are really important. The directors also, they're the ones that appoint the officers, the executive officers of the company. And then the executive officers, these are like your CFO, your CEO, they're the ones that are responsible for day-to-day management. And they also have fiduciary duties and liabilities. So a lot of times you'll see shareholder derivative lawsuits. This means like somebody on the board or an officer may have done something that caused the value of the stock to drop, or that did, they might have engaged in self-dealing or whatever it might be. The shareholders can sue the board, they can sue the officers. And it's like, there's the separation of powers within the corporation that allows for that to happen. Oh, so this is sort of, we're going to now get into the pizza analogy here. Understanding cap tables. So what is a capitalization table? A cap table is really a list of all of your equity holders, and it's showing what each person owes. So this term, fully diluted cap table, it's really important because when you do your fully diluted cap table, you assume that everything that's might be issuable is actually issued. So for example, we're not really going to get into it today, but you might issue options or warrants. For example, this is like an option means you're paying capital and it leaves a potential, like an option for somebody to purchase equity in the future. And so I may want the option to purchase like a certain number of shares in a few years. For example, that option stays open. And so for the fully diluted cap table, what happens is all of your options, your warrants, everything that might be issuable is considered issued, and it gives you your final, like at the end of the day, what is your ownership percentage? That's what the fully diluted cap table will show you. So if you think about sort of this pizza pie, right? Why this can be tricky is you have to look at your safes and your convertible notes and your, we'll get into what those are, but there might be securities that you've issued that you don't quite understand how they're going to impact your cap table. There might be, voting rights and thresholds. And so understanding what is on your cap table is key, because ultimately what your percentage of that pizza pie is, that's what's going to dictate your level of ownership and your level of control. And as a result, eventually if there's a sale or if there's some sort of M&A event or even an IPO, your expected payout or your return on your investment is going to be dependent on how much of that slice of the pie you own. And so it's really important that You understand with each issuance, with each transaction, you understand how your slice of the pie is getting affected and how each investor's slice of the pie is getting affected. Especially as a founder, you start off owning the whole pie, but as you're bringing on investors, you're owning less and less percentage, and you don't want to over dilute yourself because there's been a lot of issues, instances in the past where founders don't give themselves enough equity, and then the investors that they bring on actually end up having more ownership and control than founders, and then the founders can actually get pushed out, and then the investors sort of take over the company. And sometimes that's a good thing. Sometimes the founder is like happy to just have the payout and have the investor essentially buy the company off, and the founder has their payout and they're happy. In other cases, you want to remain as a controlling shareholder. So in order to plan for that, you have to understand and give yourself enough equity in the beginning. So the typical emerging company venture capital strategy, the growth trajectory, sort of looks like this. First, you have your pre-seed or your seed round. This is like your initial capital. Mostly this is funded through founder stock, through safes, and through convertible notes, through maybe friends and family rounds. We'll talk about each of these specifically, but that's sort of your beginning capital. And then you are able to grow the company a little bit, you can get some traction, and then at some point you really need that big check. Like you need a big round with a price round is what it's called. Usually that's like your Series A. What that really is referring to is that you're issuing Series A preferred stock at a certain price per share that's really dependent on what your valuation is. So again, we'll get into more specifics about that. But then once you raise your Series A, that gives you what's known as like your runway. So whatever, let's say your Series A is a $5 million Series A round. That's a little bit small for these days, but let's just go with it. Then that 5 million should give you a runway, let's say for 12 months or 24 months or whatever it is. And you typically have to present that to your investors. You have to say, hey, I'm raising this much, which will give me this much. This will be my use of proceeds. This is what I plan to do with the money. So then there's certain milestones or targets that have to be achieved with those use of proceeds. And then you're off to raise your second, because at some point you're going to run out of money and then you need to raise more money. And then you do a Series B round. So that's typically at a higher price per share. Hopefully your valuation has gone up. But because those investors are paying a higher price per share, they want to come in sort of on top of the Series A. They want to have a better, what's known as liquidation preference, which means eventually if there's a sale or the company liquidates, they get a preferential right to get their money back over the Series A. And so for that, you're issuing Series B preferred stock, and they usually have preferred rights over the Series A and over the common stockholders. And so same thing, you have your Series B, that gives you another runway for like another, however long. And then once that money runs out, then you do your Series C. So it's this constant sort of fundraising strategy that you have to keep employing to get to the next level. For purposes of this talk, we're really going to focus on pre-seed, seed, and Series A. So your pre-seed funding. The starting capital is usually provided by your founders. A lot of times to start the company, we hear about bootstrapping all the time. That really means, you're keeping your expenses low. It's really you're funding the company. And your initial founder stock can be as little as par value of the initial stock, which is like almost nothing. You should be pretty much paying almost nothing for your founder's stock. That's really typical. And so your founder stock is really meant to establish ownership, but it's not really going to give you that capital to start the company. So on top of your founder stock, you usually need to put in more capital into your company. You can also give founder stock in exchange for services or IP. I don't typically recommend this because the tax consequences aren't great. So my typical recommendation is in the very, very beginning, when your company valuation is like basically nothing, like par value can be as low as like 1,000th of a penny. So you can issue founder stock for really cheap in the beginning. That's what you should be doing. That's not really going to get you money, but in order to actually fund your company, a lot of people, I know somebody who sold a house before just to start her company. There's personal loans, commercial loans. People will do what's known as a friends and family round, just like going around to your friends and family. I put this in quotes because this is used pretty loosely. But if you come talk to me, I'm going to tell you that you need to have this airtight. Sometimes if people are including friends and family that aren't actually friends and family, you can actually blow the exemption, and then it can be a diligence issue later, and an investor can walk away because they'd be like, wait, you did an invalid security issuance. And then the other super, super common method nowadays we're seeing that people are raising money are safes and convertible notes. We'll get into that specifically as well. So your pre-seed funding, we just talked about some of those options. They can be debt, which is like the loans. They can be equity, like your founder stock or your friends and family round, or they can be hybrid. So some of these hybrid instruments that we're seeing now, one is a SAFE, a simple agreement for future equity. So what a SAFE is, it's very similar to a convertible note, so we'll talk about that. But a SAFE really, you're paying capital now. So let's say you might be giving $100,000 or $200,000 to the company now. As an investor, you're giving that money to the company's taking that money now, but they're not issuing equity now. The equity is going to be issued in the future, typically when there is an actual priced round. That's the typical term for when the equity is actually issued. So a few advantages to doing that, right? One is you don't have to negotiate like how much equity you're giving them now. That amount is just going to be determined based on what their investment is today and what that future price per share is going to be whenever you do your price round, right? And so you're getting the advantage to the company is that you're getting the money now, but you're not having to issue the equity now. And the advantage to the investor is that it's a simplified process where they can invest and get their foot in the door without sort of having those price round negotiations, which can be really lengthy. And that's why a lot of institutional investors will typically take the lead for those price rounds kinds of negotiations. A convertible note is very similar, except it's more of a loan. So a SAFE is an equity instrument. It's not a debt instrument. What that means is there's no interest rate on a SAFE. There's no maturity date on a SAFE. Typically, it's like open until you do your price round or until there's an event that triggers the issuance of the equity. For a convertible note, there's a maturity date typically. There's interest on that loan. It's like a loan, but it has the option to convert to equity at certain triggers. So, for example, if there's a price round or certain other triggers, like let's say there's something particular milestone that your company has, like when you have a certain amount in revenue, for example, you can negotiate certain triggers for that note to convert to equity. So they're very similar, except the convertible note, you do have interest, you do have maturity, and so it's more of a debt instrument. And then it has the option to convert to equity. So these are all different types of pre-seed funding. One thing you really need to understand, though, when you're doing SAFEs or convertible notes, you could be agreeing to grant preferred equity, right? So let's talk about the SAFE. You're taking in money now and you're saying, hey, I'm going to grant you this equity later in the future. In that future, though, you're giving them preferred equity. And so what that looks like is when that equity converts, let's say you do your Series A round, your Series A preferred stock issuance, they get Series A preferred stock often at a discount to what the other preferred stockholders are getting. And so even though you're entering into a SAFE now and you're not giving equity now, you're basically agreeing now that those people become your preferred shareholders. So what does that mean? We need to understand what preferred equity really means, because even though you're early stage and even though you're not granting it now, you've made a promise to grant it in the future. So you've already promised those preferred rights to those people. So what does that mean? Oh, this is just more information about the SAFE. We just pretty much talked about all of this, so you guys can refer to this slide later. So what does preferred equity mean? Preferred equity means that you're giving an investor preferential rights in exchange for investing capital into your company. So what are these preferential rights? So usually there's financial and economic rights. So you as a founder, you might have common stock, but once you grant an investor preferred stock, you're saying they get a higher liquidation preference. What that means is if there's a sale or you go bankrupt or something like that, hopefully, let's talk about the positive scenario. It's a sale. You're selling your company. That means you're getting money for your equity. The preferred holders will get a higher price per share. They'll get a higher payout. Or if there's a dissolution or there's some sort of a liquidation event like a bankruptcy, the preferred stockholders will first get their money before the common stockholders do. This is because they're sort of taking on the risk, right? They're investing a lot of money into your company. And so they need to have these rights as a way to guarantee that their investment is going to be worth something at the end of the day. So they've got financial economic rights. They also typically negotiate management rights. So when you have your first priced round, your first preferred equity or Series A preferred stock, your Series A preferred stockholders typically can elect directors, or they can maybe designate a board seat or have a board observer seat. Now, if we think back to the slide where we were talking about the separation of ownership and control, why is this important? Because their ownership is also going to dictate control, right? So if they're able to elect, board seats, or if they have certain designated board seats, they now can have control over the direction of your company, who you appoint as officers, what kind of business lines you open, how you run the company, all of that. They also have voting rights. So in addition to the board rights, they can negotiate, and these are often typically in the documents, certain consent rights. These are called protective provisions. So what this means is, let's say you want to open a new line of business. You might need their approval to do that. Let's say you want to hire a new CEO. You might need their approval to do that. Let's say you want to take on a loan over a certain threshold amount. You might need their approval to do that. So when you're bringing on preferred holders, you are often giving them rights to be able to say yes or no, like veto rights. Like you cannot do certain things without getting their approval. So it's really important to understand that level of control that they're going to have once they become preferred stockholders. There can also be co-sale and drag-along rights. So co-sale and drag-along rights, they're very similar. Co-sale means, let's say somebody wants to sell their equity in the company, then a preferred investor can say, oh, well, I want to buy that equity, or I want to also sell my equity. A drag-along right could be, let's say, the investor finds a great deal for your company. There can be a negotiated right in there that if they find a certain amount of like a threshold deal, so let's say sometimes you'll see like 4x. That just means if they find a deal that's giving them 4 times their original purchase price, so like the return on the investment would be 4x, 4 times the amount. This is an example. Then they can actually force a sale of the company. So these are, again, negotiated really, really early on. So you need to understand right at the price round, like what are these potential exits that could happen? And the other thing is, of course, information rights. That means an investor has rights to examine your books, your records. A lot of times, even before they'll issue the equity or before you'll get into the term sheet phase, which is sort of the beginning phase where you're really outlining some of these terms to see if there's alignment between the investor and the company. They'll want to do due diligence because they want to see, like, have you kept up with your books and records? Have all of your issuances so far been right? Do you have the right IP? Do you have the right assets? All of that. So, and of course, your financials. So they have the right to examine all of that by law. So that's preferred equity in a nutshell. We'll see sort of how it works in your first price round. So how does the first price round happen? Let's say you've done your pre-seed funding, you've gotten your founder stock, you've got a few safes, you've got a few convertible notes, you've been able to build your business a little bit, you've got some traction. Now an investor wants to do a price round. What does that mean? Your first price round is the first time you're really establishing a valuation benchmark. And I want to make this really clear because I've seen a lot of investors and companies talk about safes as if the valuation cap in a safe is really a valuation, and it's not. The valuation cap, when you see that term in a safe, it's really a part of a formula that determines how much equity you ultimately will get, that percentage. So a valuation cap is extremely important. But it's more of a function of how much the equity you'll get. Like it's more of a part of the formula. It's not actually establishing a valuation for your company. The first time you do that is your priced round, because that's the first time an investor is buying equity at a specific price per share in your company. That is based on your valuation. And that valuation is super important because that's sort of now where you're starting from. So it establishes what your benchmark is, and it's going to influence now the terms for the future round. So you're starting here, hopefully it's going to go up from here. So that means it's going to be, influencing what are the shareholder rights you've agreed to now. It's not just the valuation itself, but it's also the various other terms. So the shareholder rights you've agreed to now, the board composition you're agreeing to now in your Series A, all the various committees, approvals, the equity incentive plan, all of that you're establishing or you're doing now at your Series A, that becomes your benchmark, your starting point for the future. And so Series B will typically start there, and then we'll ask for more preferred rights. Your first round is also the first time you'll see that major dilution for your founders and your early investors, because all the previous safes and convertible notes will convert at your first price round. And then it's usually a major milestone, which signals confidence from institutional investors. So your first price round is like a really big deal. How's the valuation determined? It's usually a collaborative process between the company and the investor. So typically a company will have an idea of what its valuation is. When you pitch to investors for your first price round, you're going to propose a valuation that's based on your own assessment of the company's potential, its growth trajectory, its competitive advantage. The competitive advantage portion is really important because every time you're saying, hey, my company has this potential, this growth trajectory, they're going to ask you, well, what about other companies that are similar to you? Who are your competitors? How are they doing? What were their valuations like? What does the industry overall look like? You have to really back up your valuation. Investors will then conduct due diligence. They'll do comparable company analysis. And then the valuation ultimately is usually negotiated and agreed upon between the investor and the company. So what that typically looks like is you have a pre-money valuation. So let's just give an example. Maybe your pre-money valuation is 5 million, right? And then your priced round, let's just say the investor is going to invest 5 million. So you're starting at 5 million pre-money, and then your investor is investing 5 million. So that puts you at 10 million post-money valuation. So understanding again what's pre-money, how much you're adding on, and that's the total, it's the post-money. Understanding that is also really important for your negotiations, and also certain safes and things like that. We'll talk about the valuation cap in terms of pre-money versus post-money. So understanding like exactly what you're talking about is really important. That's typically what the valuation looks like. Let's do a little really simple example here. In this example, the pre-money valuation is 3 million for this Series A. Let's say you're raising 1 million. 3 plus 1 is 4, so that brings you your post-money valuation of 4 million. You have a certain number of outstanding shares, right? That's pre-money. That's 6 million. Let's just say these are again just given. And then somebody's investing, you're issuing 2 million shares. And so at the end of that round, you're at 8 million shares total. And so you'll see sort of how that might work out. You'll have common shares, you'll have preferred shares, and then the percentage ownership, that's your fully diluted percentage ownership, meaning at the end of the day, after you include the common stock, the preferred stock, what is your ownership? So you'll see that your ownership typically will change. It'll, everyone's percentages will go down, and then the preferred equity holders, their percentages obviously go up because those are the new holders. Again, to really remember that all the previous safes and convertible notes typically get converted at this round. So what that looks like is you'll have a Series A preferred stock. Those are the investors that are actually that are actually investing cash, and you're issuing Series A preferred stock to them. Those are your Series A preferred stockholders. And then you'll have a shadow series, usually like a Series A-1, for example, which is the exact same terms as a Series A, except those people are the safe holders. They're getting converted at a slightly lower price. There has to be some incentive for them to invest early on. And so they usually, their incentive is that when that equity is issued, it's issued at a discount. And so for less money, they're getting more shares. So they get the same exact terms and everything except that lower price. And so it's a shadow series. It's usually called Series A1, or you might have Series A2. The more safes you issue at different discounts and different terms, they're going to convert to different series. So it'll be like A1, A2, A3. But those are your Series A holders overall. In order to do a Series A transaction, you typically will follow what's known as the NVCA form documents. NVCA is a National Venture Capital Association. One great thing is that these documents are pretty streamlined. And so the various documents that you'll have to update your certificate of incorporation because you're issuing a brand new class of stock, and all of those rights and terms of the preferred stock actually go into your certificate of incorporation. You also need a stock purchase agreement that every preferred stockholder signs. There's also an investor rights agreement that lays out all the various rights that the investors have. There's a separate right of first refusal and co-sale agreement. We talked a little bit about the co-sale rights. There's also a separate voting agreement. This will have a lot of sort of what are your board, like if a Series A holder can have a certain number of dedicated board seats, or there are certain, items that you have to get their affirmative vote on in order to do that. That will be in your voting agreement. There's also a number of board and stockholder consents. The other thing I want to mention is side letters. Even safes can have side letters. Side letters are agreements. They're just as binding as any other agreement. I've noticed that sometimes if you go to an incubator early on, for example, I've noticed that they'll do a normal standard safe, but then they'll have a side letter which has these like really intense rights. Like they have these pro rata rights, for example, which means that each time you do another issuance, they have the ability to invest more and get more stock for themselves so that their percentage isn't getting diluted. So let's say they are investing initially and they're a 5% holder. If they want to keep their investment at 5% and not get diluted, they're going to have to keep buying in each time you issue more stock. And sometimes the pro rata right will give them that ability to do that. And that will be in a side letter. So just be really wary of side letters. They can contain, provisions that are binding and they're just like a normal agreement. So have an attorney review those if you're getting side letters. All right, so common early stage funding issues that we're seeing. We'll do sort of like a red flag, green flag, right? What is the red flag? Incorporating in the wrong jurisdiction. The green flag version of that is incorporating as a Delaware C corporation. Again, like you might be able to, there are companies now that are California corporations, Nevada corporations. You can incorporate in any state, but certain investors want the certainty and predictability of a Delaware C corporation. Why is that? Delaware has this sort of long-standing favoritism amongst investors. There's a few reasons for that. One is it has really low franchise taxes compared to other states. For example, right off the bat in California, you have to pay an $800 minimum tax. In Delaware, it's $400, so it's half the price. And in addition to that, Delaware also has a really great jurisprudence when it comes to corporate law. There's a separate Delaware Court of Chancery that actually hears only corporate law cases. They have judges that are trained in corporate law. And so that is where if you have issues with shareholders or you have issues with corporations, like that's where you want to see that case go. You don't want it to go to some random judge that has no idea what, doesn't really do corporate law. So that's why Delaware C corporations are usually preferred. Again, the red flag being you're incorporating the wrong entity type. So if you're an LLC, but you're looking for investors that are institutional investors, they're going to ask you to be a corporation. How do you fix that? It's pretty easy. Most of the time you can do a conversion from an LLC to a C Corp. So a lot of people, they'll start off as LLCs. And then when they're, because, maybe they're not ready for outside funding and a corporation is more expensive to maintain than an LLC. So you can stay as an LLC for a number of years, let's say even. And then when you're ready to have your outside funding, you do a conversion to a corporation, and then you're ready to have your outside funding. Another red flag sometimes you'll see when you're doing pitches, a solo founder without a team. This is really hard for some people. And I get it because it's really hard to find co-founders, and sometimes it's your baby. You're like, I really want to do this, and this is my, my thing. A lot of times investors really want to see that you have a strong team with expertise, because they're going to know one person can't possibly know everything. Like, one person can't be the manager head and then also the financial head of the company. So they want to see, like, are you getting a CFO that has really strong financial expertise, for example? Actually, under Delaware law, there is a rule that you can't have the president and the CFO be the same person. Like, the CEO and the CFO can't be the same person. A lot of people don't understand that. But it's actually a requirement that you have at least that separation. Yeah, Tanya.
I just wanted to give you a little bit of a time warning, because we do have students who have a class after. So we probably have about 5 more minutes. So
Okay,
yeah,
thank
yeah,
you.
it goes
Yeah,
so fast, right? Yeah, yeah.
Yeah, I know, it really does.
Yeah.
Okay, so real quick, red flag, giving away too much equity early on. So the green flag is giving away equity that has restrictions, vesting restrictions particularly. That means you can't just take the stock and walk away. You have to actually be in the company for a year, 2 years, 3 years in order to get that stock. That guarantees that your incentives are aligned, that you're going to stay with the company and help grow the company in order to essentially earn that equity. This happens with employee stock options as well. Red flag, corporate formalities are not followed. Green flag is keeping the clean records and corporate approvals, especially when it comes to equity. The other thing is really important to keep in mind is like tax and IP matters. I'm not a tax lawyer, I'm not an IP lawyer, but those are, definitely get professional advice around those. Founders takeaways, I've sort of hit the nail on the head over and over again with this, but really understanding founders equity and cap table management is really important early on. And then of course your investor outlook, like what are your investors looking for from you, and understanding the rights that you're negotiating. I really wanted to get to this slide. This is sort of the current trends that we're seeing now. This is really important, I think. We'll start off in the top right here. You'll see that if you look at the green color, which is early stage funding, it's actually lower than previous quarters, but the total is really high because of late stage funding. We're seeing more late stage funding, and actually half of that purple bar is one deal, which was the recent OpenAI deal. Yeah, so that's pretty crazy. And then the other trend that you'll see that I really want to talk about is like this boom in AI, which is on the bottom here. AI is one of those industries that's doing really well. Drug development, drug discovery is still also one of those industries that's doing pretty well. The one thing I want to show you in the top right here in the early stage, you'll see that those numbers are down, but not much. But if you look at the bottom two here, what I really want to point out here is the overall volume in number of dollars isn't much lower, but the number of deals is far lower. So what that tells us is that there's smaller deals for larger cash money, right? So you're seeing, really like $10 million, $15 million Series A's, but you're not seeing the number, like before it might have been a larger number of deals, which for smaller money. Now you're seeing a consolidation, smaller amount of deals, but for larger money. So you're getting more of a runway. And there's a number of reasons for that. The current economic trends that we're seeing as well is definitely stifling deal volume a little bit by number. So, all right. So now I really want to open it up to questions.
I really love that. I'm so glad that you spent some time.
There.
Oh, sorry, I didn't mean to cut you off. I was just going to say, I'm so glad that you spent some time on that slide, because a lot of that I wasn't aware of. Like, I wasn't aware of a lot of that, and that's good stuff. But I know we have a lot of questions and like no time left. So there were a lot of questions from the people here, and then also from the people at home. If we can just try to get as many as we can. One of the first questions I got from here: do you need to form a C corp before you actually are pitching to the angel investors? Is it better to form the corporation at the same time that you're raising the capital? Yeah.
Yeah, so that's a great question. I think it really depends, like how quickly you want to raise the money. If you want to raise money really quickly, I would say you need to be formed as a C corp, because that process takes time to convert, for example. But if you're more doing early discussions, you can still be, an LLC, for example, and then do the conversion. But
So
yeah, if you're really trying to get money in the door quickly, then I would say be
ready. Yeah, because I've heard I mean, people have asked this before because there's so much that you're doing when you form the corporation. Is it beneficial at all to, at the same time, have the attorney sort of helping you with the formation and helping you with the entire fundraising process? And the next question I actually was, would an attorney actually help with this whole process? Is this something that's like a flat rate and you're going to help me all the way till I'm done with my whatever series or safe or whatever? You know?
Yeah, absolutely. So I actually do flat rates for in corporations. But I don't do flat rates for conversions, only because that really depends. Like, for example, if you've only been operating as an LLC for a few months and you're doing your conversion, it's going to be a lot more straightforward. If you're operating for a few years and then you're converting, it's going to be a lot more documents and paperwork. So that I typically just do it like an hourly rate. But yes, so flat fees, again, depending on if it's LLC versus corporation versus PBC versus nonprofit. But I do that. I don't know what other attorneys are doing out there, but that's what I do.
Yeah. So, a question from Wendy about if you have employees in California, does that mean you have to also incorporate in California?
No, that's a great question. No, you don't have to incorporate in California. However, you will have to register to do business in California. So let's say you incorporate in Delaware, but you're operating in California. You still need to do a foreign registration, like register as a foreign business operating in California. You need to have that tax certificate in California because you're going to be paying taxes in California.
Yeah, good. Okay, so I saw Regina was asking here about, I think this is about Delaware, when they want more than one founder. I know in California you can have a single founder for everything. Can your team be contractors there, or do you pay a small? Oh, she's actually asking, do you actually have to have like 2 equity owners in certain
No,
states?
I just want to clarify something. Even on the Delaware side, you don't have to have 2 equity owners. You have to have at least like an
Board
executive
members.
officer or director. A board member usually is what the rule is. You can still be the sole equity owner, but you want to still build out your team. So initially, the reason people give equity to have people on their team is because you don't have the money to give them an incentive to join you, right? So you might not be able to pay them a really great salary to be your CFO or CEO. So then the equity is like their incentive to join the board, or it's join the company.
And now I'm looking at Regina's question. It was more about like what investors want. Investors always want to see a team. They always want to see a team. You know, how you've divided up the equity is not as important, or how they make up the team is not as important to them, that there is a team. I don't know if
and they just want to also understand, like, if you can back up why certain people own equity, like they might have a few questions like, why does this person own 3%? Why does this person own 2%? You need to be able to justify why you're giving the equity. That's sort of what they'll ask. But when I say team, they don't necessarily have to be equity holders, but they have to be like, officers or some sort of leadership role. Like, you can't be the only leader. That's typically the red flag.
Right. I think those are the main questions. I think we got all of the main questions, a lot of comments. Oh, wait, here it was. A couple more. We're almost out of time. Maybe quite time for just 2 more really fast questions. In your experience, what are some common legal pitfalls early stage companies face when they're looking for funding?
Yeah, so I actually want to dive in a little bit onto this team question, because that is one of the pitfalls. And somebody asked specifically, like, can you have a contractor? So one of the major pitfalls I see is you're giving a lot of equity to somebody who's just a contractor. Or, you think like, oh, this person can be a
I see it all the
CFO,
time.
and they're really just like a part-time contractor.
Right.
I think when it comes to like who is your team, they want to know who's like all in with you. Right? And so giving a lot of equity to a contractor can actually be a red flag, because that contractor has a million other businesses or whatever, right? Like, we don't know how committed they are to this company.
Right.
In the eyes of a founder, there's this disconnect between who a founder thinks should be an equity holder and who an investor thinks should be an equity holder. I call this like the benevolent founder problem, because like the founder wants to be really nice and they're like, hey, I'll give you equity if you do this. I'll give you equity if you help me build this. Then when an investor comes in and we're like, that's not a major enough milestone for them to have this much equity.
Right.
They're not committed enough to your company to have this much equity.
And you've given up way too much of your equity for absolutely no reason, for something that maybe you could have spent $5,000 on, and now your company's valued at 3-4 million. And
exactly, it's almost like it's like a short-term solution to give away the equity, but then in the long term becomes a big problem. Whereas, if you just buck up and do the cash route, like give them cash for it, you're protecting yourself more in the long term. Because an investor has a much higher bar of who should be an equity holder, and then a founder usually has a lower bar of who should be an equity holder, and that sort of becomes a big red flag in the due
Yeah.
diligence negotiation process.
I agree 100%. So I know there were a few more questions. I'll forward them on to Anusha and get back to you on them. And some of them I might be able to answer. Um, uh, we have to end for a lot of the people who are leaving. So I'm going to go ahead and end the recording. Thank everybody who has a class next or has somewhere else they need to be. Thank you so much for being here. Thank you to our guest speaker, Anusha. We always love hearing from you. It is always so informative. I learn something every time we sit down together. Every time we do this, there's something else I take away from it. So thank you, thank you, thank you.
Thank you
I'm
for
going to go ahead and
having
stop
me.
the recording. Yes, of course. Always, always. So stopping the recording.